You know, when they had what happens in Vegas stays in Vegas, and there is, you know, some local, you know, tension on that because of who it was sold and who owned it and that type of thing. But putting that aside for a moment, it's become so common, that phrase, that when you are watching a television show or a movie and they use, well, what happens here stays here, is that an infringement on that slogan?
Well, that's a great question, because when you have a popular slogan, you can have what are called good problems. If everyone's using it initially, that's a huge success. Right. It has worked its magic. It has created the brand, and trademarks are all about a brand. And when people start using a trademark in other ways, it's almost like it can start, the control and the brand start slipping through your fingers. Trademark is all about the product or service and the mark that represents it. And usually trademark owners like to keep a really strong tie with those things. They do stuff like get a trademark registration in Washington. They monitor other people using the marks. And that's really, I think, where your question is going. If someone else is using a mark, you know, is it authorized or not? Is it harming us? Are consumers confused by it? Is it watering it down? There's a lot of really interesting trademark cases about what's called dilution, where people have famous trademarks, companies, and they then say, well, wait a minute, somebody is using it in a way that's diluting our great image. There was recently cases about Visa credit cards. There was a guy who had a website called eVisa, and the court decided, yeah, that's confusing. But in other cases, there was a case about Lexus, where people were brokers who were helping people find and buy Lexus cars. And they had a website that says, it was something like, you know, we buy or we help find Lexus.com. And there was a lawsuit. You know, that's a famous trademark. It's worth a fortune. It stands for the quality automobiles. And they said, you can't use Lexus in your website name. But in that case, the court said, well, you know, nobody's confused. The standard is whether consumers are misled, confused, don't get it. But here it was really clear. What their website said was, and if you went to the website, it was very clear, was not Lexus, it was some brokers. So there, you know, people have these gray areas. People can disagree with trademarks because the standard is whether consumers are confused. Reasonable minds differ. I think consumers are confused. You think consumers are not confused. So it's like an ongoing process. But a successful mark like what's, you know, happens in Vegas stays in Vegas. That's a good problem. You have a success like that, you can handle all the issues that pop up later.
Kind of like Kleenex.
Yeah, some trademarks have been lost. They become what's called generic. I'm trying to remember the right examples. I think Escalator is one of those. An Escalator,
Escalator was a company?
Was a brand name. Yeah. There's a couple others like that. I think I'm correct in remembering that Aspirin was originally a brand name. Yeah, I'm not sure if they lost their mark on that, but it can happen. This is why, if you have a good mark, you need to police it. You need to do what Lexus did, which is, you know, I'm not comfortable with people using our name. Let's go after them because we don't want to become like Escalator, where it becomes generic.
And this is so complicated with the internet, because now you have whatever, I don't know, let's make up Best Buy. You can have the Best Buy negative website, where people who don't like Best Buy or have their own website with the term Best Buy in it.
Sure. Well, you know, what's happening there is, again, is there consumer confusion? And what about freedom of speech? I think there were some famous cases. It was, you know, famous studio followed by the word sucks. And there was a case about that.
And politicians.
And politicians. And guess what? First of all, I know it sounds very logical and easy to figure out, but court said, guess what? Consumers are not confused. If they see a site that says studio sucks or whatever, they know it's not the studio's website. They know that it's somebody exercising their First Amendment freedom of speech to criticize. Right. And with the internet, one of the huge issues now is the incredible ease with which anybody can get out there with an opinion, the incredible ease with which people can defame people or companies. I mean, anybody can have a blog and say anything, and even if you have the legal wherewithal to go after them, get the blog taken down, the internet being what it is, it may be impossible to really truly erase those defamatory comments from the internet. They may be out there forever. And it's very different from sort of saying, that issue of the newspaper is, needs to print a retraction on the internet. Those things can be out there pretty much forever. So it's a whole new world of comment. There's, tremendous freedom of speech, importance to the internet, and it's an incredibly valuable tool. Look what happened with recent political events in the Middle East or in China. The internet and Twitter were essential to people spreading important information and opinions. But it also means that those who have a bad intent and want to do harm have this incredible worldwide platform. It's the law does what it can, but there are limits, unfortunately.
How does it work with music? Oftentimes you'll hear just a small, a few bars of a song, or is there a limit of what you are allowed to air or play or reproduce in music without having to pay a royalty?
Boy, I wish it was that simple. I wish there was a hard and fast rule, but this goes back to the Tyson case also. With copyright, the basic principle is if someone owns a copyright, no one else is supposed to reproduce that work without permission. Okay, so that's the sort of, carved in granite rule. But there's also, like with the trademark thing we were just talking about, there's freedom of speech, there's the First Amendment, there's fair use, there's criticism and commentary. We can talk about if we're reviewing a new recording by somebody, we can play some of it just to illustrate it. That's a fair use. And this drives people nuts because it's very hard to know what's a fair use and what isn't when there's no actual law that says 20 seconds is okay, 21 seconds is an infringement.
Is there an industry standard that they use?
Not really. I hear all the time the 30-second rule, and there's a small part of copyright law about 30-second excerpts for a specific use when you're giving a demo of something that you're selling, like if you're a record store or
Right.
These days an online record store, of course. But no, other than that, I hear all the time about people asking about a specific amount of music that is okay or not okay, and it's unfortunately it's not quite that simple. A lot of it has to do with whether it's being used in a commercial way, in a way that's all about making money, or whether it's scholarly commentary, news reporting, criticism. YouTube's a great example these days, of course. There's lots of music on YouTube. There's been lots of controversy over whether it's just people having a good time or is there revenue there. And to prove the answer is not that simple, there are lots of cases over these issues. People duke it out in court, ultimately.
So is there an exception for a news organization? For instance, oftentimes you'll see, ABC will film something and they'll show it on CNN. Do they need ABC's permission to do that, or?
Well, there's what the letter of the law is. There's the sort of common practice. I think generally organizations like that communicate, say, yeah, sure, go ahead and use it, give each other permission. You often see that little line, courtesy of. And I think that's a practice that makes everybody feel comfortable that there's some sort of cooperation and the boundaries won't be crossed. There's also situations where people don't ask. Documentary films are a great example, and consistently, I think, is the right way to describe it. When something is educational, newsworthy, using excerpts of copyrighted material is virtually always held to be a fair use. Having said that, the standard is very often one where permission is sought and a notice is given. Certainly, if anyone is concerned about whether what they're doing is fair use and they're worried about, the Tyson case is a great example. Out of nowhere came someone with a multi-million-dollar claim, and one of the defenses is that it's a fair use. What's the gold standard? How do you avoid that anxiety? How do you go to sleep at night knowing you won't get the letter from the lawyer? You ask, you get permission, and then there's no worries. The problem is very often, that's a wonderful gold standard, but very often people are doing very worthy news reporting or making a documentary or changing something in a transformative way, like a new version of a lyric or something, that really is a fair use, and they ask for permission and they're denied. And that's when we get the cases where courts say, hey, you know, it was a fair use, too bad they didn't get permission, but there's no infringement here.
Now, in Las Vegas, for instance, we have a lot of shows with impersonators. A lot of these people, you know, Michael Jackson is gone, Elvis, I mean, a lot, John Lennon. So when somebody dies, they, I know the law, there's a change in the law when that happens, but I know even oftentimes with Elvis, the estate has a lot of control over what does, it does agree to or not. But can they stop somebody from doing an Elvis impersonation? Well,
we're getting now into both trademark and right of publicity areas, which are huge in the whole entertainment world, especially here in Las Vegas. And there's a couple ways that you can look at those. First of all, there's pure merchandising. And if someone is just making a fridge magnet or a cup or a t-shirt, or they want to put Elvis's face on there, they're going to need a license from his estate. This is called the right of publicity. It's using someone's image and persona for commercial purposes. And in most states these days, that right exists after someone dies. And you mentioned a lot of deceased celebrities. Applies to Michael Jackson, who lived in California. I think it's 70 years after death. Elvis was a resident of Tennessee, so after death he has rights. But when it comes to artistic expression, you know, where's that line? We go from just crass merchandise to an artistic work, a show that pays tribute to the great history of rock and roll or the great history of rhythm and blues or whatever. Well, at that point, you're doing a sort of artistic tribute to Elvis, and the basic principle there is that it's seen to be a tribute. That the audience is, again, consumer confusion. No one's confused. We know that they've passed away. No one thinks it's Elvis up there at this point. And there have been a bunch of cases on this, and over the years where it's shaken out is, there's actually a case about Elvis. Where it's shaken out is, you can't literally take their entire act and copy it for commercial purposes. That's going too far. But if you do a tribute, and it's sort of like about a period in musical history, about a celebrity, no one's confused, then in that case, it's artistic expression and it's okay.
But if you want to do a movie about the life of Michael Jackson, you don't need the family's approval, do you?
Well, not for anything that's in the public domain as a public figure. Right now, any of us could write a book about Michael Jackson by simply researching his life and writing a book about him. Same goes for a movie. Someone could do that. Where the line, again, very often there's these lines here, and the lines shift. They shift on the facts and on the case law. Typically, with those sort of projects, what they want to do is have it authorized. They want to get the cooperation of the estate. They want to be able to say, we have inside information, and that becomes a contract.
It's a credibility issue, isn't it?
It's credibility. It's also a competitive edge. I mean, right now, for all we know, there's 4 movies about Michael Jackson's life being made without anybody's authorization because he was a public figure. That's okay. But if one of them has the cooperation of his family, then that movie's going to have a competitive edge, and so that's something worth having.
Yeah, and I suspect it'll be something on the Navy SEALs, or the movies coming out and the books coming out with the Navy SEALs on the Osama bin Laden.
Yeah, SEAL
capture.
Team 6. You know, this one studio applied for a trademark for, I think it's called SEAL Team 6. There was an outcry. Yeah. And they withdrew their application.
Yeah. We're just about out of time. This is fascinating stuff. Thank you, Bill Cameron. Thank you very much, Corey. And to be continued. This is an ongoing problem in the law.